time is just gone 8:32 p.m. as we continue with the show this evening, and it is Wednesday nights with myself, Inayet, Wadee. Now, for the last half an hour of the show, we are going to be focusing on an issue that is of concern in South Africa, and we are talking about organized syndicates operating, invading residential properties, and this presents major issues, major legal issues, and for want of a better term, we are talking about housejackings, which is now the new phenomenon in South Africa. And this evening, we're joined by two attorneys. We've got Fiona Worwood, who is with Cohen Harper, Madikizela attorneys, and also Eesa Ahmed, litigation attorney at ARM attorneys with us. And as we wait for both our guests to get on screen, we welcome, I see Fiona's coming through. Fiona, good evening to you and welcome to the show.
Good evening. Thank you very much for having us on the show. It's very nice to be here.
Yes, and Eesa as well to you. Assalamu alaikum and welcome.
Walaikum salam. Jazakallah for having me.
Yes, Fiona, I just want to start off and just to get a brief overview as to why this is so important for us to actually talk about these organized syndicates. And this has become a major issue. It's become a major talking point in the country and also an issue of major concern because, we are talking about the invasion of properties, and also looking at some of the discussions that have been taking place surrounding this and to understand what is the difference, because on the one hand we're talking about trespassing, but on the other hand we talk about invasions and going right up to illegal occupations.
Yes, yeah, and I think one of the main points to first raise is obviously this is a prevalent issue, not only your CBDs. I think previously it was your Pretoria CBD and Joburg CBD. Everybody it's been in the news about Joburg CBD and building hijackings. But it is now more and more. You see it in your affluent areas, Sandton, Parkmore, Northcliffe. It's not just limited to your CBD areas. It's becoming more and more prevalent in your residential areas, any sort of buildings, even just standalone houses have started becoming victim to these sort of syndicates. So I think it's becoming more of a topic to talk about because of the fact that it's becoming more prevalent. And really, it appears that our SAPs and our states is not able to really adequately address the concerns and this issue that's coming forward.
Yes, thank you for that, Fiona. And also, Eesa, when, as Fiona mentioned, this is not a new phenomenon because we've seen what has happened in the CBDs. She's mentioned places like Joburg, Pretoria. We know, areas like Hillbrow, all these areas. So this is something that has been taking place for a very, very long time. The key issue here is, now that it's now gone into other residential areas, and you've got experience as well, Eesa, where you've dealt with issues with land grab issues in particular.
Yeah, so our firm was mandated on a few matters in respect of land invasions, and what basically happened on those matters, they were, and you would see, it's known in our community that this issue is now very prevalent in the Lenasia area and also in the Vaal area closer towards Roshni and wherever it may be. We dealt with two matters of the same nature, and basically what happened, there were large portion in the one matter, there was a large portion of land that was invaded. People went on there, they demarcated stands, and while they were in the process of doing their earthworks and demarcating stands, we approached the High Court on an urgent basis and we interdicted them from demarcating and from constructing shacks or whatever the case might be on that property, and we were successful in those applications. We also dealt with another matter in Lenasia. There was a very big residential development that was being built. It was about 75% complete. Development was very big. It was 84 units, 14 blocks of units. And in the process of construction, they went in there, they hijacked the property, and they started occupying those units. And they also started selling units to the general public that were obviously innocent, and because they obviously thought that these kingpins had the authority to sell these units, and that wasn't the case. And we again approached the High Court on an urgent basis, and we got our court order. So it's becoming a very big issue, and I mean, it needs to be tackled. Like Fiona just said, SAPS has to be more proactive in this issue, and that's what comes in now when we differentiate between trespassing and and occupation of land. Because at the initial stages, when people trespass onto the land, I mean, SAPS has the full authority to go in there and stop that access that's being gained without the owner's consent. But because they're not doing it timeously and effectively, what happens is then we're left with an occupation issue, and then we have to follow the laws in terms of the Prevention of Illegal Evictions and Occupation of Land Act, this, that, the other, which makes it much more stringent on property owners. So the key to this whole thing, or one of the keys to this whole thing, is that SAPS has to be proactive. They have to carry out their constitutional mandate in an expeditious manner so that it doesn't prejudice landowners and property owners.
Yes, Fiona, just talking about SAPS and SAPS doing their work now within the legal framework, what should SAPS actually be doing, or what can they do? What can't they do?
So the moment there's a trespasser, I mean, I think, Eesa, you pointed out that there's a difference between a trespasser and then when it actually becomes an unlawful occupier. The moment it's a trespasser, you can have, well, hopefully SAPS will come in and actually remove or eject the trespasser. They have the authority to do that. You should be able to call your local SAPS or your police service and say to them, we've got this trespasser on our property. They have no lawful right to be here, and SAPS should technically come and remove them. But what we've been seeing in our practice is SAPS are saying that they don't have the authority to arrest because they don't see trespassing as a major offense. So at best, they can give a fine, and then they get inundated with all of these sort of minor penalties that they can impose, and there's no real ramification because they're refusing to arrest and actually remove the person. And as Eesa mentioned, if you can't come right in terms of the trespassing, then it moves generally in towards occupation. And once it's moved into occupation, you have to comply with the PI Act. And that's quite a stringent, strict act to be compliant with. And sometimes it can take a normal PI application, which is your eviction application, can take months to actually come right. It is great that we can go to court on an urgent basis, as Eesa has said, but it's not every matter that you're able to go to court urgently, which, you know, it becomes a lengthy, drawn-out process. PI in itself, the act itself, has many, like, not loopholes, but many things that a landowner has to consider and that the court considers before an eviction order is granted. So we've gone to court ourselves and my firm on an urgent basis, and we've been successful. We've also, in one of our most recent cases, asked the court to actually request that SAPS supply a report because it was, you know, found that they had allegedly been colluding with the actual hijackers of a building, hijacking that we'd been involved with. So they were directed to supply a report, and, you know, SAPS sort of say that their hands are tied, and you know, I can't speak too much about the actual case itself, but we're finding that SAPS is not very cooperative. They're not very helpful in dealing with this. And if you're not fortunate enough to go to court on an urgent basis, you have to do the normal route, which, you know, it can take a long time and it's extremely costly.
Well, certainly, Fiona. And also, Eesa, just looking at existing legislation that we have at this point in time, and, you know, whether we're looking at the Trespass Act or whether we're looking at, illegal occupation, I'm sure there are various acts actually that govern, you know, or trespassing or illegal occupation. Is that sufficient at this point in time? I mean, how, just from a non-legal person's perspective, just to help us out now, I'm not too sure whether Eesa is with us. I don't see him on screen, but perhaps, Fiona, you can actually address this issue if we have lost, I see Eesa on screen right now. Eesa, just looking at legislation, is it sufficient at this point in time? Is it enough, for people like yourself, for the legal fraternity to actually act and obviously on behalf of people who are affected either by trespassing or illegal occupations?
100%. So, like you said, we deal with two basic acts when it comes to trespassing and occupation. So, when we deal with trespassing, we deal with the Trespassing Act. It's a very old act. I think it was amended in 1959, if I'm not mistaken. But there has been a new bill that's been prepared. So obviously that's going to now be discussed, and we'll see whether it's passed off and whatever the case might be. But whatever it is, with regards to trespassing, Like we said, the Act makes provision that, look, if you gain entry without the owner's consent to his property, then you are subject to imprisonment. And in terms of the new bill, that's going to be, from what I've read, it's going to be amended to, I think, 2 years or so. Then we deal with occupation, and then we deal with a level of permanency with which somebody is occupying a property. So there's an element of regular occupation, there's some degree of permanency. It's where somebody habitually lives. And then we deal with the PI Act, which is the Prevention of Illegal Occupation and Illegal Evictions and Occupation of Land Act. Now, what's very important to understand is that once the Constitution came into force and effect, everybody has a right to housing. It's one of the most important rights that's been enshrined in the Constitution. And as a result of that important right, that everybody has a right to shelter, has a right to housing, the law is now stringent, and courts are very reluctant to just grant an order for eviction because they don't want to see poor people out on the street or whatever the case might be. So the law is now stringent, and we have to follow the PI Act very strictly. So what basically happens is an application has to be brought before court. It's either the High Court or the Magistrates Court. You have to comply with the directives. You have to give them notice. You have to give them. You have to bring a second application to authorize further notices that must be served on the occupiers. You have to cite the municipality as an interested party in the proceedings. The notices must be served within a certain time period so that the occupiers are not prejudiced. And all these have to be followed, like I said, because courts are reluctant to put people out on the street where they don't have any shelter or housing. So it does become difficult to an extent. And what Fiona pointed out that was very important is that it takes a very long time. So on an unopposed basis, say your illegal occupier doesn't come to court, you'll probably get your order within 3 months, 4 months, just dependent on which court you're going out of, number one, and number two, how busy that court is. And secondly, I mean, they can oppose it, and then you're looking at a 6-month story. And once you're successful in your application, I mean, they can still bring it on appeal before the High Court or a full bench and take it to the SCA. And it's happened many times in our courts. Where they abuse the provisions of the law and they appeal it to the SCA, then they appeal it to the Constitutional Court, and by the time you know it, the property owner is slumped with thousands of rands in legal fees, number one, and 3 years have passed where these people have just occupied this property unlawfully. So those are basically the two acts, and this brings me back to what I said in the first place. The trespassing is dealt with in the Trespassing Act. And SAPs are responsible to expeditiously carry out their constitutional mandate. So if somebody comes onto your property on the first day, you report it to SAPs, they have to expeditiously take legal action against them, whether it's arresting them, imprisoning them, giving them a fine, or whatever the case might be. Because if and the problem is they don't do that timeously and expeditiously, and then they start occupying the property, and now you're sitting 2 months later and there's a degree of permanency with which they occupy the property. So that's basically the issue that we're dealing with. But like I said, the provisions of PI are stringent, but they must be followed, and that's because of the rights that are enshrined in the Constitution.
Yes, and Fiona, also, when we look at these syndicates that are operating, they've become very, very sophisticated in their modus operandi, how they operate, and they do understand the process, they understand the law very, very well. And as Eesa pointed out, it could take up to 2 or 3 years for someone to illegally occupy a home before they actually get out. So they don't even stand to basically lose anything. They've occupied your home, they've enjoyed the benefits, but like I said, is the sophistication within which they operate.
Yeah, and I think another thing to point out is these syndicates not only have contacts and are in some instances able to collude with SAPs in order to assist them. I think in one of our matters, we had evidence of the fact that perhaps SAPs had assisted them in changing locks and actually gaining access to these buildings. But we'll also, if you consider the syndicate itself, they're taking possession of these buildings or these houses. Generally, what they do is they are putting tenants in themselves, or saying to the tenants or the actual lawful occupiers who are currently in occupation that any rentals must be paid to them. So they're benefiting on a number of levels. They may be benefiting from having occupation themselves. They may be benefiting in the form of getting rentals like rental income themselves, and they have no downside. They're not paying the expenses for the building. The landowner is still responsible for the municipal accounts, for the water, electricity that's being used. And I think what we were seeing is the arrears become so much, and almost to the point that the amounts outstanding in the municipal rates and the losses that the landowners are now having outweighs the worth of the property. And then what they do is they just abandon it. They don't want to deal with their property anymore. They sort of leave it to the hijackers, and they sort of try and wash their hands and don't want that property at all. And as Eesa correctly pointed out, if you are going to go the PI route and do an eviction application, just some of the other considerations that the court has to take cognizance of when you do this eviction application. And again, just to sort of allude to why it's such a difficult process and a lengthy process, is the court is mandated to consider circumstances. So they have to consider the occupants. So if they're elderly, children, disabled persons, households headed by women, that's a consideration that the court has to take cognizance of. They also have to consider whether alternative accommodation is made available for these unlawful occupiers. So in some of our cases, we have to submit what's called a housing report that we get from the municipalities. So, and that's to show the court that there is alternative accommodation that's available for the unlawful occupiers. And then the last consideration that the court looks at is whether it's just and equitable for an eviction order to be granted. Now, before you can even go into the merits of the matter and have these considerations before the court, most of the time, the eviction applications are unopposed. And you follow the process through. There's an interlocutory process, which is an in-between process. And the matter will remain unopposed, and it will go. And then on the day of the hearing of the actual eviction matter, generally what happens is now opposition will stand up. And we've seen this in a number of cases. So now you've 6 months down the line, you've completed all of the tasks or all of the the steps that you have to follow in terms of PI. You get to the final eviction date, which is obviously months down the line, and then somebody in court, or obviously if it's an online because of case lines, if it's online, somebody will stand up and say, no, now we're opposing the matter. And they have a right to justice. So in essence, the court grants them sort of the opportunity to then file their correct opposition, because obviously the matter was unopposed and then it becomes opposed. And it's like a further delay. And these syndicates are well versed with the process of PI, the difficulties that need to be followed, when it is occupation and PI should be followed. And then obviously they're very well accustomed to these delay tactics. So 9 times out of 10, right when you're looking for your main eviction order, somebody will stand up and oppose it, which means you now have to remove the matter from the unopposed roll, put it on the opposed roll, and it's a further delay. And the moment it's opposed, you now have to follow the opposed procedure. And you're looking at 8 months, if not years down the line, because they may not file their papers when they're supposed to file them. And then you get stuck in a further interlocutory application where you're compelling them to do certain things. And it's a mess. It becomes a very lengthy, drawn out, and very costly exercise, as Eesa pointed out.
Yes, Eesa, and also, we're not only talking about housing, and we're not talking about illegal occupation. And earlier on, before we came live, you were also talking about hijacking of developments.
Yeah, so like I said, we actually dealt with a matter in Lenasia. What happened was there's a very big residential development. Like I told you, 84 residential units, 14 blocks. It's on a very big plot of land. And 75% into construction, it was hijacked by a syndicate of people. They took control of the property. At that point, they were trespassers. Clients went through to SEPS and said, listen, there's people trespassing on my development. We're still in the process of construction. SEPS were complacent and did nothing about it. And then what happened was a week later, we were sitting with an issue where certain people have occupied that property, number one. And number two, the syndicate is selling units for 2,000 rands a piece to the unknown, to the public who's innocent. And then we have to prepare papers and go to urgent court. So we go to urgent court. It's opposed by the syndicate. We are successful, alhamdulillah, in their application. And then what happens is they take it on appeal to full bench. And Shukr, the judge, looked through the papers and he ruled in our favor. And ultimately, the SEPS had no option but to accompany the sheriff and help him carry out his mandate to go in there and gain control of the property back and hand it over to the lawful owners. So yeah, I mean, if like I said, Lenasia, the Vaal area, Vereniging, wherever there's empty plots of land, I mean, now you can see that people are coming on there, they're demarcating stands, and before you know it, it's thousands of people, and the public can't do anything about it, let alone the owners. So it's a very big issue, and I would urge people who's got vacant plots of land or whatever the case might be, that they should secure those properties, because it becomes an issue. I mean, if people are going to go on their demarcate and start occupying the property, you're going to be left with approaching the courts, and it's very, very costly. We did one in Vereniging as well, where we just got a report back from the sheriff. Now we've got our final order to take control of that land, but there's 1,000 shacks on that property, and for the owner now to get them off their properties in excess of R1 million. So is it worth it for him, or does he just now leave his property and this is what it's been, and move on with his life? So yeah, it's like I said, I would urge owners who's got vacant plots of land, secure your properties, and if anybody trespasses onto your property, get legal assistance immediately. If SAPS is not going to assist you, approach your attorneys, and they'll be able to assist you with these issues.
Yes, Fiona, Eesa speaks about R1 million. Just how costly is this entire process?
No, I think he's very correct in how expensive this process can be. I mean, once you've just got the court order, so let's put aside the legal fees, which can be hundreds of thousands of rands, especially if it's opposed. I mean, your legal fees alone are exorbitant. I mean, it's a lengthy application. It's not just a very quick, go to court and sort it out. Even on an urgent basis, it is a very extensive. It's an extensive application that you're bringing. It's a lengthy process. But once you've got that court order, your sheriff's fees alone to try and have an eviction order carried out is a vast amount. I mean, we've once had 40,000 rand sort of looking at just for the sheriff to act. And if you have an instance where you have to get a private security company to assist. So we had a case where we were dealing with illegal trespassers, and we managed to bring in on an urgent basis. And that was a building hijacking where we had a syndicate come in. They were heavily armed. They were in the process of changing locks and forcing tenants out, or telling the lawful occupants, the lawful tenants, that they need to pay them their rental to the hijackers. And we managed to say that it was trespassing, and obviously go to court on an urgent basis for trespassing, and we were given an order that the sheriff could carry out an ejectment. But because of the inability of SAPS and the fact that they don't want to assist with these matters, our client ended up having to appoint a private security company to assist. And alone, those sort of costs are also hundreds of thousands of rands. It's not a simple, let's get SAPS involved, and once we've got the order, there we go, we can go and get rid of them. It's a very expensive process. And if you end up having to appoint a private security company to assist because SAPS doesn't have the resources, or they just can't assist at this stage, they don't have, the inclination to assist, then the sheriff does appoint these private security companies, and the landowner ends up paying for this. And those costs are on them.
Yes, and also, Eesa, looking at SAPS, and I noticed both you and Fiona, talking about SAPS, because that is the first point of call. Just looking at the capacity within SAPS, do they have the capacity, or are they just not interested, or are they just incapable of dealing with the situation?
I think it's a combination of everything. I think it's a combination of incompetence, lack of resources and manpower, and also, like Fiona correctly pointed out, a lot of times they are undercover with these syndicates that are hijacking properties. On one specific matter, I can remember very clearly, we got a court order which specifically mandated SAPS in one of the suburbs to assist. As per the court order, they were compelled to assist in gaining control of the property and handing it over to the owners. And when we approached SAPS, they said, look, this is not how our station runs. We'll do it when we feel like. So, like I said, it's a combination of everything. It's incompetence, it's lack of resources and manpower. And then you have the unfortunate thing where there's corruption, and they're in cahoots with the syndicates that are hijacking properties and invading land and whatever it may be.
Yes, and Fiona, just looking at legislation, looking at the government, what more should the government be doing?
Well, I think, I want to go back to our first line of defense, which is being SAPs. I think if they were more operative and willing to assist and had the capacity, a lot of these problems may resolve themselves. For instance, if it was trespassing and you called your SAPs, your local SAPs, and said, please, come and assist with this, I've got a trespasser, and they actually did their due diligence and their work, then the step of them even gaining access to the property is already sorted out before we even have to deal with the unlawful eviction. I think if we had a more proactive police force and less corruption, I think that would work. And in terms of legislation, I think, as Eesa pointed out, we do have a draft bill that hopefully will resolve and sort of clean up some more of the technical and the burdens for the trespassing and update it. I think that's also bringing it towards today's time. And I think PI, to a certain extent, should be looked at. I think it's not a very old act, but I think it was drafted in a different time where these syndicates weren't a problem. And, the lengthy things that you have to go through to comply with PI, the process alone with the service of a Section 4.2 notice and things like that, for certain instances, it shouldn't be necessitated because it's a syndicate that's gone and done this. There should be a faster, more affordable route for, your average everyday person who's dealing with this. Because what's happening is the average person can't afford an eviction application. So either they just leave their premises and try and sell it with an unlawful occupier at a loss, or we're seeing that it's the businesses and the more commercial entities that are able to sort of pursue these routes. Having said that, though, I believe that there is a hijacking unit that the Joburg Metropolitan or the City of Joburg has started. And we have seen in one of our matters a positive act from them. So people who can't necessarily afford the legal fees can always attempt to approach them, but they're not entitled to do any form of eviction. So then we were then brought into the matter to help with the eviction side of things, because the hijacking unit doesn't have jurisdiction, or they were saying that they don't have jurisdiction to assist with that. But I think that our legislation should be updated. But I think our first call to action would be to have the SAPs actually be proactive and take a stand and do their mandated duty. I mean, I think that most of our court cases are either compelling SAPs to do their mandate and fulfill what they're supposed to be doing already, and they just don't. They don't come back. They ignore it. If you serve the application on them, you don't get an acknowledgement that they've even received it, or they say that it wasn't served on them. I mean, it's a vicious cycle. They're not prepared to help in the beginning, and they're certainly not prepared to help once you've got the order and you actually need some manpower to assist with removing people. Yes. I think that would help.
Well, thank you for that, Fiona. I see we are getting closer to time. Just final thoughts from you, Eesa?
Yeah, inshallah, like I said, look, if anybody needs assistance, feel free to contact your attorneys on an urgent basis, because, I mean, otherwise you're going to be left with a very big problem and a very expensive problem. Having said that, look, we make dua that Allah protects our properties, Allah protects our homes, and whatever the case might be. But like Fiona says, the incompetence lies with SEPs. I mean, we've got the law and we've got facilities to implement that law. And if we've got incompetence in those facilities, then the law is not going to be implemented correctly. And then we're left with this problem that we're currently facing.
Well, Fiona, as we say, the lady has the first word and the last word. Final thoughts from you.
No, thanks for having us. And as Eesa correctly stated, it's very important to consider the timing of things. So if it is still a trespassing element, then of course try and approach the court urgently, get your attorneys involved as soon as possible, and not wait for it to become an unlawful occupation, because it does take a lengthy time to solve that. And I agree with Eesa fully that I think it's the incompetence of the SAPs. It's not necessarily solely on the legislation that should be updated. I do think that we have legislation that we could make use of better, as long as we had SAPs and like our actual support system that should be there, which isn't.
Well, to you, Fiona, and to Eesa, I thank both of you for coming on, for talking, and for unpacking what you have with us this evening here on Salam Media. All the best to you, to both of you.
Thank you very much.
Thank you for having us.
Have a good evening.
Assalamu alaikum.
Fiona Worwood and Eesa Ahmed joining us, both attorneys, and just unpacking the legal issues with regard to these illegal invasions and trespassing and occupation of properties. And with that, I'm going to be signing off for tonight. It's been wonderful being in your company. From myself and the team, Assalamu